for the kind words of introduction. My esteemed colleague and friend and someone who I adore in terms of academic legal achievement, Professor Bismi Gopal Krishnan. There are so many doctors who are participants here. To many of them, warm good afternoon. I'm a little nervous because we have already people who have achieved. Some of them I know, and some of them who have already done significant research work. I don't know why you are participants in this session. I'm really a little worried now. I think some of them have to be on this side. They have to be the resource persons. So I think, what I usually try to do is to get into an interaction and a dialogue or a debate. I have no intention to give a lecture on interdisciplinary legal research, though Professor Bismi wants me to do that. But I think I would love to have an interaction. I would love to have your ideas. And I think let's get into some kind of a mutual experiential sharing on interdisciplinary legal research. If you all are okay with that, friends, I would request you to maybe unmute yourself or use the chat box, and probably, let's try and debate or discuss what this topic is all about. Okay, so that's the agenda for the day, friends. Second, I don't have any structured presentation, though I have a PPT which I will on and off probably look into. I don't have a structured presentation at all, because my idea is, I'm not going to give you the methodology that is there in interdisciplinary research. I'm just going to tell you how did I do some of my research work or research projects. I'm glad that Professor Bismi just mentioned about a new project that we have just received from the government. It's also interdisciplinary. So, when we made the proposal, I think I can share some insights about how I made this proposal and what were the key areas, so that, we can actually debate and you can actually guide me about how I should do this, because I have another 2 years to complete this project. So I would probably look forward to your guidance about how I should approach this topic as well. But to start off with, I would like to start by provoking your thoughts on whether or not legal scholars must do interdisciplinary research. What do you think? Should legal scholars do interdisciplinary research? I hope the audience responds. If you have not done in the past sessions, at least this session you can utilize it. I'm probably checking if you just have logged in, or are you seriously listening to this webinar? Anyone has an idea? Yes, please go ahead. Yeah, you're using. Okay, so some of you are responding now. Yes, the response is coming in. Should do is what? Okay. Okay, yes is what? Okay, great. Okay, Rupa is also there. Yeah, okay. Only few responses. Okay, many of you said yes, but I don't think so. Okay, so just to the 4 of you who have responded in the chat box, I would want to humbly disagree with you, or probably put across a contrary view to you. I think lawyers should not do interdisciplinary research. It's the antithesis to the title that is given to me. You don't want to ask me why? Do you want to know why I think so? At least, say something. Yes, why? Okay, that's good. That's good. At least some curiosity in the audience. Okay, that's great. I believe that, look, as lawyers, what is your core strength? As a law professional, what is your core strength? Your core strength, according to me, is, friends, a doctrinal study of law, which we call as the positive school of law which studies law as it is. So, to be honest, interdisciplinary research, according to me, is a distraction. It is. Because it actually snatches you away from the hardcore law, which, according to me, is a study of legislative actions and legislative enactments. See, one of the things that I've always found with our young researchers is the word interdisciplinary is so much highlighted, or the word socio-legal research, as it is called sometimes, is so highlighted, so signified, so emphasized, so advocated, so preached. Uh, we actually focus too much on the social part and then the legal part. I think it should be legal social study, if you want to call it, not social legal study. I would want to put my discipline first before sociology, because you are doing PhD in law, you're doing research in law. You're a hardcore lawyer first, and then a law researcher. A lawyer cannot be missed in you. So as lawyers, what are we trained in? We are trained in reading the law. We are trained in interpreting the law. We are trained in the use and application of the law. And hence, to me, the doctrinal study of law is the most important thing that lawyers must do. And you must focus only on that. So, which means, according to my preliminary observation as a point to place before you is, I do not think that lawyers must do interdisciplinary research. I do not think so. I think as a philosopher in law, and Professor Bismi may probably agree with me, your PhD in law is about the philosophy of law. It's the doctorate of philosophy that you get. You must think about the law, you must read the law, and you must look at what the law ought to be. That is what a lawyer is supposed to do. And that, according to me, as a philosopher, is more desk work, it's a doctrinal work. Interestingly, friends, when we do research, how much of our research is contributing to legislative policy making as an outcome of a research? I think this is something that we must also think about. Are you, as a researcher, contributing to new law? Are you, as a researcher, contributing to new policy? Right? So if you're not doing it, I think your legal research is of probably not of great value. To be honest, friends, as a lawyer, your strength is case law. Your strength is not case study. I hope some of you understand what I'm trying to say. As a lawyer, I repeat, your strength is in case law, not in case studies. Your strength is in reading the case facts, the issues, the judgments, not looking at case study method, which is more of a management philosophy, or the school of management follows the case study method. Lawyers have the case law method. Our strength is in judicial interpretation, judicial application, in the terms of court interpreting the law, interpretation of language, interpretation of words. So, friends, I think interdisciplinary research is a distraction. It's a deviation from a hardcore legal research. Today, I'm sure Professor Bismi and some of my friends who are already PhD examiners will understand. When we evaluate some research work, I find pages and chapters of everything except the analysis of law. We find a lot of chapters, it's about that case study, this case study, that data, this interview, that stakeholder consultation, this data being put in different, I met so many of these people. consider that. Right? I want to view this quite in a sense that there is nothing wrong if a lawyer wants to do hardcore law research or legal research. But the fact remains, now the other side of the story is, why have we started looking at interdisciplinary research? What is the need why lawyers are now asked to do interdisciplinary research? What is the requirement? Friends, I think the requirement is, if I have seen research of the times that we are speaking about, pre 1991 and post 1991. I think a lot of what happened with globalization, liberalization, and privatization has impacted even our ability to do research. See, the early times of law was restricted only to a few laws and legislations and few departments. Today, law is quite widespread. It is widespread. Law applies in every profession. In every discipline, there can be some kind of a law. And hence, the changing scenario is that law has now entered various other disciplines, and it is actually trying to bring on regulations of various other disciplines. And because law is intersectionalized with other disciplines, we are looking at interdisciplinary research. One great example of the early time interdisciplinary research is the research in technology and law. Friends, when intellectual property came in, we would find a lot of research on intellectual property. Now, I'm sure in our audience, has anyone done research on IP? I'm sure there could be one or two. Can I just get yes or no? Anyone who has done research in IP, intellectual property? Or who is doing research in intellectual property? Okay, no one is. Okay, no, I believe that, friends, if you're doing research in intellectual property, yes, you should know the law, but do you want to know a little bit of science, technology, and innovation before you try to understand intellectual property? Yes or no? Just answer that first. Would it be useful? Would you become a good IP lawyer if you knew science, if you knew technology, if you knew engineering? Amit says yes. Amu says yes. Okay. Now, to be honest, friends, if you ask me, an IP lawyer can be a good IP lawyer. He can be a good IP researcher. He can be a good IP teacher, provided he knows a little bit on the science side. Because remember, it's about patent. Now, for example, say we are talking of patenting of software. Let's just take one instance or example. Unless you know the business of software, unless you know the development of software, unless you know whether a software is a product or a service, will you actually be able to appreciate the patenting or the intellectual property that is applicable to software? So I think the intellectual property regime that came through WTO and the kind of changes that we brought in India through TRIPS was probably an eye-opener for us to visualize the fact that law is not something that you can completely appreciate and understand. Please note, law, when I'm saying modern day law, the law post liberalization, globalization, and privatization, the law in contemporary times, is a law that only does not make prescriptions about governance. It can actually look at regulation of science. It can talk about regulation of innovation. It can talk about interventions in technology. And hence, a new breed of lawyers and law researchers were required to understand two things. Yes, you must be an expert in law, but do you have an additional expertise in science as well? Do you understand the science behind the law? Friends, the science behind the law is important because very many of us have been trained only in law and we have not been trained in science. So we have to probably move from law to science and appreciate, oh, okay, This is the science behind the innovation. This science was newly developed, and hence this may be patentable or not patentable. So, how does a patent lawyer even give an opinion saying that this product can be patented or not, unless he appreciates the science regarding it? So, unless you have understood the business of the science, the applicability of patent law is not going to be successful at all. Do you appreciate this, man? You think you agree with me on this? Okay. Okay. I have got a few thumbs up. I have got a few yes. But I think a major part of the audience still is a little silent. I think, are you contemplating what I've said so far, or do you have any questions to what I've just said? Okay, before I just open it up for questions, I just had one last point to make before I wind up on my first issue. On my first issue about whether interdisciplinary study is a distraction or a deviation for good lawyers or hardcore lawyers. Friends, I got into environmental law quite early in my career, thanks to what I started with CEERA at the National Law School, and I'm sure many of you know.
Enrollment.
Okay, that's okay. I think someone has unmuted. Sir, can you mute yourself, please? Yeah, that's okay. So, I got into environmental law. Yes?
Internal assessment
Professor Shankar? Giri Shankar, can you mute yourself, please? Yeah, that's fine. So, I got into environmental law, friends, around 22 years back. And, I joined the Center for Environmental Law at the National Law School. And to be honest, I was very keen and interested in environmental law. Is environmental law, or a good environmental lawyer, should he or she know about science and environment or environmental studies in general? What do you think? Okay, Dr. Jacob has to say yes. Okay. Yes, yes, yes. Okay. Okay, friends, I think if it is the same Dr. Jacob, I just want to address to him. He's a good friend of mine. What I'm just trying to say is this, friends. In one of the training programs that I attended, and I addressed that training program, it was for the Pollution Control Board officers, and I was supposed to train them. The interesting factor is it came down to the evidence that is required to prove an environmental crime. Okay, the evidence part. So water pollution. Okay, so how do you go to a court, a criminal court or a magistrate court, and say that the industry has actually contaminated water? You can't make allegations. You can't blame that the industry has made pollution, right? You can't shout, but you have to prove. Now, what is the proof or the evidence that is going to the court that will actually substantiate that the industry has contaminated water or polluted water? Friends, please note, I can quote water law, I can quote any other sections of CRPC, I can shout, I can say something, I can argue, but what is the evidence that will prove the environmental crime? I hope you will appreciate this, friends, that the proof will be the sample of water pollution. And to be honest, the sample of water pollution means that, look, there is a standard which says below this, no pollution, above this, it is pollution. The BOD content and so on and so forth. So let me not get into the technical side of what water pollution is. I'm sure Rupa and others have already studied this. The point that I'm driving you to think is, friends, I realized quite early in my life that if I have to specialize in environmental law or I have to work in environmental law, it is inevitable for me to get into the details of this science called environmental science. Unless I know about environmental science, my understanding of environmental law is going to be incomplete, is going to be insufficient, is not going to be adequate enough. Because finally, friends, Law is evidence driven, and the evidence in environmental law is scientific evidence. It's technological driven. And hence, I need to appreciate the same, I need to research the same, I need to analyze the same, maybe I need to criticize the same. And hence, friends, in my field of study, that is environmental law, it's inevitable that I have to do research in an interdisciplinary manner. Because let me warn you, not all subjects require interdisciplinary, not all research requires interdisciplinary, but there are few that are inevitable in the interdisciplinary context. Friends, today in environmental law, we talk about the phenomena of climate change. I hope everyone understands what climate change is, especially with the summer that is on in India. I've been talking to a few people from probably 2 days, and everyone has only one complaint, that it's intense heat wave in India. So people from Delhi, Guwahati, Kolkata, I was in Kolkata just yesterday. Everyone is just talking about the heat that India is experiencing, and many of them, attribute it to climate change. Yeah, true. The phenomena of climate change. Now, friends, the point is climate change is a phenomena. It's something to do with weather condition. It is something to do with global warming. It is something to do with the science behind the Earth's atmosphere. Now, understanding this phenomena is one part. But if you're looking at the legal response to climate change, that can only be based on understanding the problem of climate change. Friends, the problem of climate change is not a legal problem. Is it a legal problem? Is it created by law? Is climate change created by law? Is it a law-created problem? No, it's unfortunately a creation of, yes, human activity has contributed to it, no doubt about it, but it's not a response of law. Law has to probably respond and abate climate change. So if anybody would want to do research on climate change, I think that person, I would say, first thing first, do you understand the science of climate change? Do you appreciate the science of climate change? Are you good with the vocabulary and the words that are used in climate change? If you are so, only then a legal research is justified. It is adequate, it is sufficient, it is a good response. So friends, in my research, knowing about the different disciplines that interact with law is an inevitable exercise for a good lawyer to be in. Otherwise, environmental lawyers would actually be incomplete in their discussion and in their analysis of the same. Interestingly, friends, I don't know if I should say this. In environmental law, the role of law is very minimal. The maximum role is the role of science, engineering, and technology. That's dominating environmental law. And that's why you will notice, friends, even the National Green Tribunal, which is a quasi-judicial body, does an interdisciplinary adjudication of disputes. What did I mean by this? Anyone? I talked about the NGT. It's a very unique body that gives judgment based on what? Quickly, friends.
Based on the decision of the laws, if there is a violation of environmental laws.
Amit, you will also notice that NGT always has one legal member and one technical expert. Two members decide environmental disputes, Amit. So it's not only a legal member that decides disputes in the National Green Tribunal. National Green Tribunal, every dispute has to be decided by a technical member and a judicial member. You know why? The Supreme Court itself, Amit, as early as in 1998, recognized that environmental dispute itself is not a hardcore legal dispute.
Sir, in
I don't know.
Kolkata region, the NGT, they are not giving any kind of favorable decision as we have thought.
No,
Because there is
favorable or unfavorable. No, we are not getting into that point. The point is, I'm just saying, even the adjudication requires people from two disciplines to adjudicate the dispute. See, interdisciplinary study or
Sir, as a
interdisciplinary research.
high court lawyer, we must only file if there is an glitches in administrative decisions or there is a constitutional perspective. But regarding the technical realities, as a lawyer, we don't go into that thing. But whenever we file a case before the NGT, they goes into questioning on that point. And sometimes as a lawyer, we don't have that kind of answer.
I agree. I completely agree. But the point you need to draw is the reference of the requirement of two disciplines to come together. That is the significance of this research and study that we all have to appreciate right now. And let me tell you, I don't know if some of you would be interested to recollect this very interesting factor that, this kind of a Supreme Court kind of an acknowledgement that all disputes cannot be only decided from the from the premise of law. And I think law must transgress into other things before they can come to a conclusion. The Supreme Court thought this in what we call as the Delhi air pollution case. It's not the recent one that I'm talking about. The Delhi air pollution cases started about way back in 1999, right from the Taj Mahal case to how CNG was introduced as a clean fuel or cleaner fuel, and how public transport system in Delhi shifted to CNG. Because the Supreme Court over there said, we need a committee of technocrats in the automobile industry, in the fuel industry, to actually guide us to say what we must do. So we are not entirely capable of understanding the issue. Forget providing the solution to it. What is the issue? Can lawyers really appreciate non-legal issues entirely and completely? I don't think that's possible. And hence we require assistance. And let me tell you again, in many cases, the Supreme Court was appointing amicus curiae to help the court in arriving at framing of the appropriate issue and providing solutions and getting the kind of evidence and arguments that are required. But again, the Supreme Court said that is insufficient because most of the time the amicuses were lawyers who are supposed to be independent and neutral and then guide the judges. So they said, no, that also is not going to work. So let's appoint a technical committee. Let me highlight over here to many of my friends over here. See, even the NGT appoints technical committees to help the National Green Tribunal arrive at certain kinds of conclusions. Technical committees. So I think the field of environmental law is a classic example why interdisciplinary study, research, analysis, and expertise, I highlight that, is the need of the hour. Expertise is the need of the hour. There is a dearth of these professionals, friends. There is a dearth of professionals who understand two disciplines with equal importance, who can actually give justice to two disciplines. That is the kind of professionals that I think has a great demand too, and a great research value too. And I think that is where my focus of attention is to draw and say that these are classic cases and examples where interdisciplinary research should be encouraged, should be viewed, should be, I must say, brought about so that legal research has more authentication. Can I give you one other example? And this is a kind of a classic example that most of us will definitely appreciate. Health law or medical law. Friends, if you look at medical law, or what I call law relating to medicine, I would always want to put law before any other discipline. Okay, I'm quite, I'm a little, I must say, obsessed with my own profession first. So instead of calling it medical law, I prefer to say law relating to medicine. I hope that's okay. I hope you will also follow the same. But the point is, I'm just saying. Now, when you look at law relating to medicine, friends, I have seen a lot of presentations that talk about medical negligence. They talk about the Bolam test and so other kinds of tests that have been developed. But the point is, to prove medical negligence, is law useful or is medicine useful or medical science useful? The point is, negligence, friends, is nothing to relate to the legal side of it. To prove negligence, you must know whether there is a standard that has or that is acceptable, and did the doctor deviate from those given standards? And only a doctor in the same profession probably can certify and tell this doctor actually committed negligence. I don't think lawyers have that competence to even decide. Right? So, if you look at medical law, it's the most interesting facet of what I would call as interdisciplinary study. Medical law gives you all that very interesting aspects to the same. But at this point, let me just share one small research that I took part in. And I'm sure some of you will appreciate this thanks to the COVID pandemic and the time that we are in right now. You know, I conducted a small research on a very interesting agency called the National Pharmaceutical Pricing Authority. Have you heard about it by any chance? NPPA. Has anyone heard about it? If you can just confirm heard, not heard. Okay, Dr. Jacob has heard. Okay. Okay. Friends, the National Pharmaceutical Pricing Authority, please note it down. Okay. It's an authority that is controlling the pricing of pharmaceutical drugs. Right? Now, not much highlighted, not much debated, not much discussed around, but we decided that we wanted to do research quite early when this authority was created. And interestingly, you will notice that they have come up with a list of the national list of essential medicines. I repeat, the national list of essential medicines. I hope you know about the Essential Commodities Act, the Essential Services Maintenance Act. We have an essential list of medicines as well. Right? Now, when you look at this, you will notice that drug pricing in India can be regulated. There can be a price control on pharmaceutical drugs by this pricing authority. So I just wanted to look at the authority, its powers and functions. Right? I started with that. And I wrote pretty well. I did research about the powers and functions and so on and so forth. But then I got stuck. You know, where did I get stuck? Where did I get stuck? Look, it's not about the arbitrariness of bringing drugs into the list, which drugs to bring in, which drugs not. Any life-saving drug can be brought under this price control because you know pharmaceutical companies can exploit the market, exploit the prices, and hence in a country like India where we practice socialism and social welfare, I think price regulation is a must. Yes, price regulation is against innovation. A lot of these companies may decide to sell outside India, not in India. Then you are looking at parallel imports as an issue. All that I had already done, friends. That's not a big problem for me. No, it was not a big problem. That I think every lawyer could dissect. But I got stuck. Because, friends, so far, I've done some kinds of research where I was able to get a scientist, an environmentalist, to review, vet, to join me, co-author, write, all that. I got stuck because, friends, there is something called economics of law. Socio-legal research is very popular with all of us because we find sociology easy. We are all, every lawyer is a sociologist in one sense, aren't we? Yeah, we are all, right? We understand the social behavior and the social norms because every lawyer comes from the society. So sociology is very easy, friends. trying to understand, stakeholders, victims, interviewing them. This is all the sociology of the. Where is the economics of law? I was stuck.
Sir,
Can you tell me where and what I was stuck with? Sasidhara, where you want to come?
may I intervene, sir?
Please, sir.
When you talked about the drug price control order, now I know at least 100 cases where patients complain that these drugs purchased under the price controller at reduced price are not working well.
I agree.
And the doctors, yeah. Now I'm also slightly connected with this pharmaceutical industry.
Right.
For the information of everyone, there is 85% quality, there is 65+% quality, there is 50% plus quality, and there is 35 plus quality. So you may get 35% plus for a cheaper rate, but for 85% you will have to pay.
Yeah, the efficacy of the drug is always a challenge and issue, especially even with generic manufacturers. So I completely agree with what you're saying, sir. But the point is, can anyone help me understand where I got stuck? Any anticipation? Anyone to foresee what I might have come across as a challenge? No?
Maybe ensuring quality and
No. That is not what economics comes in. You know where economics comes in? Yes, Dr. Jacob, you're absolutely right. You're absolutely right. Thanks for that intervention. How does the Pharmaceutical Pricing Authority fix prices? And let me tell you, if a government agency fixes prices, which, okay, you fix price, that means it's not market driven, right, by demand and supply. Can I not challenge it under being arbitrary, not being very scientific in calculation of the price? What is the justification for A drug to be at this price, B drug to be that price? Is there a formula that the pricing authority has to follow in fixing these prices? Is there a formula? Today, a COVID vaccine is available at X price, 250, 750. The government may arbitrarily probably say, okay, this is the price. But when an authority, and that's, because of the pandemic, I think no one challenged it. That's a different issue altogether. Even the vaccine manufacturers did not challenge it. It's a different issue altogether. But when a pharmaceutical pricing authority in normal times fixes prices, what is the formula in fixing that kind of price? Is there an economic theory model that the authority must apply? Because see, rule of law and not rule of men is what applies, isn't it? So the most critical part of the law on pharmaceutical pricing is this economic theory model for fixing the price. And it took me 15 days even to understand what that was. And I couldn't finish my research if I had not understood that model. My research would not have been complete. Yes, it is great to talk about pharmaceutical medical law. It was great to talk about rest of the things. But my research would not have been complete because this is the critical way in which the authority fixes price of nearly 600 drugs, friends. Please note, 600 drugs are there in the national list of essential medicines. These are life-saving drugs. The ones that are available in a pharmacy, there is a price control fixed. I think this is where medical research is some kind of having intersection with legal research. So a lawyer has to step out to complete his understanding of the law. He has to step out. It's inevitable because you are in that area. You better actually be a good researcher by understanding the other discipline. I can give you one more example. Friends, I did research on surrogacy. And pardon me, some of you might have heard me in the past because this is one of my favorite areas that I've been researching for a long period of time. So I'm sure some of you have already heard me on this topic before. But I get dragged into this because we are talking of interdisciplinary research. And I'm very proud to say how much of research I've done in this area beyond law. Friends, the Surrogacy Act of 2021 is already in place, where commercial surrogacy has been completely by legislative mandate prohibited. But friends, surrogacy is about the medical invention of what we call as the IVF, in vitro fertilization. A lawyer who wants to dwell upon or make a law on surrogacy must understand the medical science on surrogacy. Why should we even ban commercial surrogacy? I'm still not very sure about that. I'm not sure, to be honest. Because there is a cost that is always involved. But the point is, friends, when I started doing on surrogacy, let me tell you the different issues that I encountered. Let me just give you one kind of a scenario about how one discipline will lead you to another discipline, to another area of research. And I think that is what a lawyer must attempt to do or achieve. Friends, please don't, I'm just trying to motivate you, just trying to inspire you, just trying to lay down the importance of how this kind of multi-dimensional research is core and important to modern day times. How many of us know that an amendment to the Maternity Benefit Act has been made because of the issue on surrogacy? How many of us know that? Can anyone confirm? Can anyone tell me what that is? So for those who just want to know or Google, who is entitled to maternity benefit? The intending mother or the surrogate mother, or both? Can a surrogate mother who has, bared the fetus in her womb for 9 months be entitled to maternity benefit? Yes or no? Can adopted mothers get maternity benefit? So I'm just saying, many of us, unless we understand where these are coming from, you may probably be just confined to looking at the legality or the ethical dimension of surrogacy. See, there are a lot of papers that I've seen, a lot of research that I've seen, ethical dimension. Friends, ethical dimension of surrogacy is not for the lawyers to judge. It is for the doctors themselves to judge their own ethics. Friends, ethics is laid down by each profession. I need not judge a doctor by ethics. No, I'm nobody to say ethical dimension of surrogacy. Let the profession themselves decide. That's what ethics is. But lawyers have decided that it's unethical, it's that, it is this. But I'm not worried about all that. Okay, that's fine. I think freedom of research is also core and important. But the dimension that surrogacy brought in, it actually went into so many other disciplines. Contractual issues of surrogacy, I researched. Labor issues of surrogacy started coming in. We had an interesting case. Whether surrogacy can be treated as adoption, that was another challenge. Citizenship in surrogacy was another challenge. And friends, and that's why you notice that unless we go beyond the text of law, appreciating the dimensions and issues in today's context would not be possible. And hence, a legal researcher purely sticking to doctrinal research may not be doing complete justice either to the topic or to his abilities in comprehending the challenges arising from this area. Friends, I think what I've done so far is to kind of lay down the reasons and the backgrounds of the justification for interdisciplinary research by giving you some ideas from environmental law and from medical law. Quickly, I'm just going to take another couple of minutes. I'll move on to, how can we go about doing this kind of research? how can we go about doing this kind of research? Friends, the first and the foremost is, I feel when you say talk about say medical law, would you want to look at literature from the medical libraries apart from the literature available in law libraries? Yes or no? Excellent, excellent, excellent. I think one thing that I would request all of us to do is, you cannot do a proper interdisciplinary research just by saying, okay, I'm just looking at medical law, but I'm sitting in a law library to understand medical law. That's not possible. I think just basing your literature from two disciplines, which means to justify it, you must also use the medical college library as much as you look at law college libraries. This is my first starting point. I'm emphasizing this for the simple reason is that you can't have shortcut methods to multidisciplinary research. My second point, friends, when you decide to identify the problem, should the problem be from both the disciplines? Should the problem be identified from both the disciplines? Should there be a legal issue along with the technical issue? Just think about it once. Just think about it once. Right? If you properly understand multidisciplinary or interdisciplinary studies, you will say adequate legal as well as the other disciplinary issues, you will be able to identify. And you will attempt to address it as well. You will be able to address it. My third point, quickly, friends. Would you have a guide from the other discipline as well, apart from your legal guide? Now, I want a confirmed answer here. Would you co-opt a guide from that discipline as well? I had only one answer. Others are not going to answer. Will you co-opt? Will you have an external guide? Will you want to consult someone to review, edit, critically read your work? Friends, there is nothing wrong. I think you can have your internal guide, your confirmed guide, whoever you are, but have someone from that discipline also as a co-guide. Co-opt that kind of a guide. It's important because there should be authentication to what you have done from that discipline. No, you cannot yourself determine that you've got into some authentic research and study. Or suppose you're doing like Dr. Archana was saying, yes, suppose you're doing projects or research projects like what some of us are undertaking, like Professor Bismi or me or Dr. Archana or even Dr. Jacob for that matter. Maybe I should have a committee of advisors in which I co-opt members from that discipline as well. Right? Have a doctor in place, have an environmentalist in place, have an environmental scientist in that advisory board, because they can actually review whether you have done the work appropriately or not. Friends, I think it's important that when we talk about interdisciplinary research, this kind of research should be relevant for both the disciplines as a final outcome. So I hope you understand what I'm going to tell you at the last point. The last point is, in an interdisciplinary research, please try to define your audience. Who will read my research? Who will be the audience of my research? Who will my research benefit to? if you think your research is going to be read by both the disciplines or more than two disciplines, it can be the sociology, the science, the politics, the economics of law, everybody. Then if you're sure that this is going to be the audience of my research, then be prepared, friends, to address your issues in their language as well. Sometimes. Okay. Very interesting. Do you think, our research with so many footnotes are read by an economist, a political scientist, a sociologist? Do they read our research work? What do you think? The way we put things complexly, right? We lawyers are very good at creating complexities of research. We are very good at it. What do you think? Do they read it? Will you circulate it? Will that be part of the library of, say, some general discipline library? Why are lawyers' work not read by other disciplines? See, it's interesting. Lawyers are asked to do interdisciplinary research. Are other disciplines also asked to do interdisciplinary research? Shouldn't doctors also have law? Shouldn't environmental scientists also have environmental law? And hence, friends, what I believe is sometimes the impact of a research is also critical for us to view and understand. The outcome of a research is also very important for us to evaluate. The audience of a research is something that we must understand. Whom will my research be more useful to? Will it be more useful to the patent agents? Will it be more useful for those who are doing the prior art search report while filing patents? Will it be more useful for the doctors than to the lawyers? And hence my issues, my emphasis, my problem statement, my conclusions, recommendations, and my policy recommendations also must equally fit that kind of an audience. Because we always say research must be outcome based. I say outcome based, but I always say audience based. So, friends, it's important that we understand the kind of discipline that we want to adopt. We must very clearly know whether that discipline is a comfortable discipline for me or not. Because let me tell you, every lawyer cannot be a specialist of science, medicine, law, everything else. As lawyers, we must know something about everything and everything about something, but we're not necessarily specialists of everything, right? It's not possible for lawyers to have that kind of an expertise. So, but the fact is, I think there is a greater role that you can play in society, because finally, friends, don't forget this. We are lawyers and we are social engineers. Are lawyers social engineers? If we are social engineers and we are supposed to bring change in the society and societal behavior, and that's what a true hardcore lawyer ought to be, then to change that or bring about social engineering, I think we must move beyond the tables of law. We must actually adopt law as in the society and understand societal change to law. So it's not the statute books that we should be confined ourselves to. Because if you are confining yourself to just understanding the statute, friends, I believe you are understanding what law is. But you must also know that there is something called what law ought to be. And if you have to say what law ought to be, you must probably understand how law is implemented, enforced, reacted. So I think law in action, which is law beyond the statute, you can only understand when you actually look into the disciplines of law as in different professions. Friends, let me add one last point at this stage. And then if you should have any questions for me, maybe I would just love to take it forward. Friends, we were doing some research on an interdisciplinary basis on child marriages in Karnataka in specific. Child marriage, friends, there is a law that prohibits child marriage. Karnataka has reported the highest recorded number of child marriages in the previous year. So Karnataka is a very progressive state. The number of child marriages have increased for maybe A, B, and C reasons. But understanding child marriage, somewhere I always believe you can read the law, you can interpret the law, and you can say that this is where the law says it is prohibited. Fine. But the background to law or the psychology of law is something that I understood only when I did this small research with Bangalore University on child marriages. Friends, how many couple after they turn 18 want their marriages to be validated? A marriage that was done during their childhood. How many couples want it to be validated post they attain majority? This was something that I started asking myself. Second, in many cases of child marriage, I found that girls were willingly, for many reasons, they were okay to get into child marriage. I thought the law actually wanted to protect the girl child. But the girls were actually saying, no, we don't mind, having this marriage. And I was a little disturbed over there. Because very recently there was a proposal from the government saying that let's have equal age for marriages for boys and girls. I hope you know the proposal. What is the proposal about? Anyone can just put it across. Was it to increase the age of the girls to marriage or decrease the age of the boys to get married? So I was a little worried with the kind of, yes, Amit, you're right. I was a little worried about the kind of, psychological, social issues that surround this particular area of child marriage. What is the intention of the law? Is the intention of the law to intervene in marriages and do it? If so, on what grounds? Is it to protect the physiological, physical, and emotional age of children? Is that the purpose of child marriage? Or do you think that we are having this law so that we don't want early marriages, we don't want early children to be born from these marriages? What is the purpose? How does this child marriage law justify itself on, say, customary practices of certain communities? Even today in Karnataka, we have some customary practices in which this marriage occurs, but the term marriage is not as per law. It's just confirming the boy and the girl. So will you then say it's marriage? Because the Hindu customer of the 7 rounds and circles, they're not performed. So just confirming the boy and girl, can you at least also go and treat it as marriage? Because that is customary practice. It has been happening for many centuries. And somewhere, from my small interaction, I found that the law may not be in touch with actual reality. And it's not sufficient to deal with practical realities that are happening, especially in child marriages. The law is good. I support the law, but I'm not sure whether it is in tune with practical realities. After I found the realities by my own self-study, I was a little worried. I was also worried when I spoke to these girls who were part of this protection homes, and I went up to them, spoke to them. I was a little worried. Then I, saw the law and I said, there is no correlation between the problem that we are dealing and to the law that we have at hand. Friends, there are 2 ways in which laws are made. One way is the law reacts to a problem. like surrogacy. Friends, surrogacy has been in discussion for more than 15 years now. There were two bills, ART bills as they were called. They were debated, discussed, they were never enacted. Now we got a law. And it's supposed to be so-called a perfected one because it has stakeholder consultation. But then there are certain legislations, friends, that are putting the cart before the horse. And those legislations are problematic legislations because that is where the implementational and enforcement problems start creating issues. So I think it is important that societies understand the challenges as we face today. And societies are changing, I agree. There's a dynamic change to social behavior, and the law has to respond to those social behaviors. But to document social behavior, to understand social behavior is also critical for law. Otherwise, law will alienate itself from a given society. So different aspects of this research is something that we can always look up to. We can adopt different methodologies to the same friends. That is always something that is possible. And I firmly believe that interdisciplinary research is the way forward. It's something that even the national education policy probably encourages to think about. The intersectionalities of discipline is what NEP advocates. And one thing that I have to say, that law schools, if you have to continue to be relevant, I'm sorry, I'm not anticipating bad days for law school. Don't think it otherwise. But I think if law schools have to be relevant, I think we have to get into transnational, multidisciplinary approach to the study of law. I don't think law schools must live in isolation of what is happening with other disciplines, because this is the purpose of law. The purpose of law is to apply to every walks of life, to every stakeholder in the given society. And I have gone to the extent of saying that there are two institutions that have to work very closely together, and that is law and management studies. I've always said this, especially focusing on corporate law. You will not imagine, friends, the kind of studies IIMs and management schools are doing and contributing to corporate and business studies. They're doing some very significant work, outstanding work, something that even we cannot imagine in law institutions. But then I'm worried about my corporate law researching, because very often we are just researching on the liability of companies. That's our primary focus. Penalties to be imposed on companies, our primary focus. Prosecution of companies, our primary focus. See, we are always there for an offense or a crime to happen, and then we want to react on the applicability of law. But friends, businesses are not interested for that. They're saying, okay, that will come, that's fine. But we want to know the strategies to avoid offenses. We want strategies to manage businesses in a legally compliant manner. Post facto and ex post facto. Think about it. So there is a greater demand for getting into the business in the right manner, making it profitable and others in a right manner. Yes, within the confines of what it is. So I think law and management studies can also have a great tie-up. And I think it's not something that you should only follow in your PhD research or in your LLM dissertation, but I think even in law schools, we all can actually tie up with these institutions and contribute as well. Finally, just to conclude, I think I've said this on a couple of occasions because this is an online class, so I keep repeating that I'm going to conclude so that you will at least give me some attention. saying that, okay, the speaker is putting the final point, so let me say, and I'm sure someone who's going to thank me is at least giving me some attention now, because they'll quickly have to come and thank me. So at least a couple of people are listening to me is what I'm very confident of, and that's why I keep saying last. So, so the issue is, today, these hospitals and many of these research institutions have been asked to create ethical committees. And they've been forced to get a lawyer on this committee. Yeah, because whatever the ethical committee decides, whether it is in legal compliance or not. So we are also there in their role or in their domain, whether they like it or not. Doctors don't like it. I've seen them. When I've take part in some of these ethical committees, they're like, oh, now this guy is going to lay down and preach us what is the legality of our decisions and so. But the point is, I think even they have acknowledged and understood the importance of the legal profession. I think that's no doubt about it. I think the importance of the legal profession is even appreciated by engineer. He has understood it. Now, even if I construct something good, and unless I know the law on construction, I'm going to face liabilities immediately. Right? So, lot of professions are now embracing legal research and adopting legal research, and that's where I think legal research is gaining a lot of importance. And I think it's an interesting stage and an interesting opportunity for all of us. And I believe that we should grab it with both the hands. But I think it's important that we know the style of research. I insist on this word called style of research, because I believe that legal researchers are forgetting their style of research. We are focusing too much on footnoting, on complexities of references, on the legality of the language and making it just to the legal audience. So I believe style is very, very important. But I believe the substance part is also critical. And that's why, to conclude, let me tell you the research on Atmanirbhar Bharat that we have just undertaken. I took it with a challenge of saying the self-reliant or Make in India movement probably is a policy, is a scheme of the government of India. It goes to every sector. It's there in the automobile sector, the microchip sector, it's there in the textile sector, it is there in the defense sector. The Make in India movement. The point is, many of us think there is no role for law to play in Make in India. I'm just saying, I'm thinking of the role of a law to play over there. So the Make in India campaign and the role of law is what we are focusing on. So I'm kind of forcing the idea of law in that scheme and policy of the government of India. Does law have a role to play? What kind of role can law or policy play? Is there a legal evaluation to be done? Is something that we have taken as a challenge in this recent research project that Professor Bismi was just mentioning about. So friends, few experiences that I've shared, few thoughts that I've shared, few ideas that I've shared with you. And I hope I have made some sense of this presentation today afternoon. If you should have any specific questions to me, I would be glad to deal with it. But thank you for the patience. Thank you for the audience, and thank you for the opportunity as well.
Sir, thank you, sir. Now, I don't want to put it in the chat box. I want to tell you straight away two issues. One, a medical study conducted some 6-7 years back. The investigators spotted more than 120 weeks or more pregnancies. But something less than 80-85 mothers were delivered off. There is no record to show that other children were born or anything happened. The legal difficulty, because abortion cannot be done and childbirth shall not take place. That is one issue. Another issue is the protocol, because we are dealing with law. Now, as for the antibiotic protocol, a doctor, even if convinced, shall not administer the heaviest dose at the initial stage. So some of the doctors have told me, why you are not doing it? Because you spoke about the ethics committee. Then they said, we can't. Now what happened if you don't do it? Because especially this fungus type, they survive. Then they become immune. So if you slowly increase the dosage, ultimately either the patient will die or you will have to administer the highest dose for a long time. So that will affect the immunity system. So law to control the doctors, in fact, what happens? That ends in the detriment of the subjects. So these are the two
I
issues,
agree.
and what is your take?
I completely agree with you, and that's why in conferences with doctors, we have always told the doctors that look, if you don't look at self-regulation, there would be external regulation, and this goes to even teachers and the law universities right now. If we do not self-regulate, regulation will be inevitable, because I'm sure, uh, you know, when markets grow, when there is more demand to less supply, will have black sheeps in the market. There will be shortcuts that will be adopted. There will be deviations that will be committed. And hence, inevitably, law and principles of law will have to step in. And that's what would be delivery of justice. So I think, despite the fact that many of the legal professions, speak about intervention in medicine as a matter of right, I've always said that it's not a matter of right, but it's a matter of duty that law has to do to protect consumer and patient interest. But more importantly, I think it's important to put in those standards of legal and medical practice. See, unless your profession lays down the standard of your practice, I think the law will intervene and lay those standards. So I think it's just simply about this, that while we say the ethics of a given profession, now, for example, medical law, ethics. Now, I'm sure you have heard about the Medical Council of India Ethical Code of 2002. Doctors, say that it's an ethical code, so I do not give you the right of second opinion, right? Because ethics does not have legal sanction. And I think that's a misconception. So this kind of a misconception has to be cleared. It's a myth saying that ethics does not have legal sanction. It's a myth. Ethics can result in cancellation at least of your license to practice. The least that can be done. It need not result in imprisonment or fine. So I think it's important to understand that for the professions that they practice the same. Let me also point out over here, sir, and that's where I believe that interdisciplinary issues and studies are so critical, is because now, as lawyers, what can I bring in? I can bring in the distinction between ethics, morality, and then law, which the medical profession refuses to even acknowledge that there is something called morality of the profession, morality of the law. So I think these are dimensions that we can share, we can exchange, and I think what finally does it, I think it makes our society and legal system a more robust and a more justiciable kind of a legal system. And I think we have a duty to do and collaborate as well.
Yes, sir. There one more. No, I agree with you, but it is a self-imposed code. Even this antibiotic code is a self-imposed one, not enforced one. There, what they say is, why should I take risk? In such a case, I'll be hold up. You people will take me to the court. So, not everyone, I'm not blaming everyone. And I give you a specific instance. See, glioblastoma, as you know, this is the severest form of cancer. It's most painful. And a 4-stage cancer patient has not lived for more than 18 months. So there was a clinical study to find out whether these patients will live more for more. And ultimately, case was filed in the court, but they couldn't find any non-ethical issues. But the doctors were fed up, unnecessarily interfering with our doing things. Now, patient, see, such patients, even the parents, even the family members do not like to be with them because so unpredictable in their behavior, what will happen, because of the pain. And these people are getting.
No, I agree. See, the solutions are not straightforward. That's something that we all have to accept and agree. It's not something that can be only decided by a lawyer. I think it has to be decided by someone in the profession itself first, and a lawyer in terms of checking the legality of its application. But the point is, we have seen the medical profession, if I can use the term, getting into practices that may not be in tune with at least societal ethos and values. We have to understand, we have to accept it. Now, we are not saying it is between capitalism or socialism. Can doctors make money, or can they charge prices or not? No, I'm not getting into even that debate. But the fact is, see the human rights angle to it. Now, let's take the one issue on surrogacy that I'll just substantiate with you. Now, the issue of insurance to the surrogate mother, the issue of medical care to the surrogate mother if something happens to her, was never thought by these fertility clinics around the country till the time, see, most of us react only when an accident or an incident occurs. The fact is, couldn't you have anticipated that the surrogate mother's life would be at risk when she is actually bearing this child and is going to deliver the child? Can something happen to her? Something can happen to one of her vital organs of her body, and shouldn't you have taken care of it even before the law would make a prescription of the same? I think these are things that I think even for that business leaders or business corporate managers, as I call them, when you talk about the law of insider trading and so on and so forth, the corporate frauds that we see every now and then, I think it's all the doing of the same profession or the same business, and the law has to react. It is inevitable to lay down public order, to lay down morality, to lay down the systems of the country. I think the law has to play a significant role in that. So law can be reactive, it can be proactive as well. I think proactiveness of the law works better for me, but reactive is an inevitable part. I think we have to.
Thank you, sir. Thank you. No, the problem arises when judges and lawyers think that they know everything.
Yeah.
In those cases, only these problems. This glioblastoma, I wanted to point it out from that angle. Because they were not aware of the complications, but they thought that they know.
Yeah. Sure, sir. Sure.
Thank
Sir, if you permit, I'll just take some other questions because of the paucity of time. I'll just take questions from KS, and he says, please elaborate on the fact that it's a distraction. I don't know why should I elaborate, but I think it's a distraction at times. Why it's the distraction is because I think what I feel is I would always encourage you to do interdisciplinary research, provided. Dr. Manoj Kumar, can you just mute yourself, please, if you don't mind? Yeah. I would always say it's a distraction because it all depends upon whether you are going to lose your ability to analyze law, critique the law, and actually provide solutions in law. That is where I call it a distraction. Because I've seen the conclusion of most interdisciplinary research. The most conclusions are that, yes, implementation of law is weak, enforcement has to improve. Fine, that's it. Apart from that, there is no concrete legal solutions that legal researchers provide for. Most of the recommendations and solutions are sociologically based, are politically based, which I think is a disservice to you being a lawyer first. So please don't get distracted in terms of the outcomes of your interdisciplinary research. Please don't get distracted. I think you are doing interdisciplinary research to evaluate law. You're doing interdisciplinary research to actually make the suggestions of what law ought to be. Right? So as lawyers, you please focus on that as the outcome is what I would like to say. Okay. I'm not saying for other disciplines. I'm sure we have people from other disciplines. You should focus on your hardcore area is what I just want to highlight upon, right? So contribute in your field. Yes, borrow from other fields. It's fine. But if you're just trying to make very general contributions, which, no field can adopt, no field can benefit from, then it's obviously a distraction. So that's where I just wanted to say that. I hope that's not. Yes, understood. Great. Okay. Okay. I do have some other question. Let me just check in the
There
chat
was a
box.
question just above by Amit Upadhyay.
Yeah.
He has asked. Okay. You want me to read?
No, I'll do that. Thank you, Ruben. I think climate change induced problems. Yeah, I think the climate change issue is a major issue, Amit. Okay, Amit, I hope you're from law. Are you from law? Sorry, can I check? Just check that. Is Amit from law? You are.
Yes.
Amit. Okay, Amit. One of the interesting facets that I've seen over a period of time, and please let me tell you, not everyone can dedicate time for every topic or every subject. But climate change has been a problem, Amit, for a long time, right? Right. Say Kyoto Protocol happened in the year 1995. Ozone and that were already issues in the 1980s. We know global warming is happening. We know India is a vulnerable country for climate-induced problems and challenges. Cyclones are a must. Man-made activities are also contributing to climate change. There is so much of noise on climate change. Paris Agreement has happened. We are trying to achieve Paris Agreement goals. All that is fine. Great. Amit, my point is, we are getting all over the place on climate change. We have got into all over places on climate change. We have done everything. Every issue on climate change has been debated, including, say, can a young child go to the court and say climate justice? Even that we have done, right? The younger generation wants to protect this planet for their future. So don't do this blah, blah, blah and other things. Yeah, we have seen that kind of, championing of the cause for the next generation that we should fight climate change for. But the point is, Amit, how many lawyers thought that India may require a law on climate change? Are the existing laws dealing with climate change? You have a Ministry of Environment and Forest and climate change. So we have added and CC. But does India require a law on climate change? Do we need a law? Are existing laws sufficient? I'm sure there have been some 100 theses in this country in the last 20 years of climate change, in which climate change would have been discussed. And out of that 100, I'm sure 50 are law, kind of PhD research that have been done. In how many places have we seen the discussion on climate change? How many workshops? How many seminars? But how many have attempted to draft a law, be it a section of a law or be it an entire law for climate change? Yeah, do we need one? Yes, we can evaluate. If you need one, should we draft one? Is what I think a legal researcher's contribution should be. Right? And interestingly, the point is, where does the law on climate change gets its strength? From the problem. And the problem is, climate change problem is not coming from law. Climate change problem is coming from science. So if you understood the science of it, you may probably be able to draft the law in a much better manner. And from just generally our understanding, friends, please look at the CEERA NLSIU bill on climate protection. If you just want to refer to that, it's available online. We have drafted a bill called the Climate Protection Bill for the government to adopt. There are a couple of bills. Sri Jayant Sinha, a member of parliament, has also submitted a bill on climate justice. So I think the reaction of, say, any problem that comes from, science or comes from, society, I think the response from lawyers should not be just appreciating the problem, the magnificence or magnifying the problem, saying, oh, the problem is like this, it's all fine. Saying case law is fine, according to me. But finally, friends, come down to the real crux of the issue is about the response and how the law should react. I think that should be the real focus of any kind of research-based outcome that we are attempting to look at. Yeah, I think, even to be honest, comparative research is a great research. It's always the bedrock of legal research. I'm sure it should be the bedrock of
Evening,
most
sir.
political research as well. Yes, Dr. Soni?
Yes, sir. Good evening, sir. It was really an interesting session.
Okay.
Thank you very much for enlightening so much on the potential of interdisciplinary research. I just want to share with you, sir, it had really helped me when I was doing the PhD to understand the real reality and then to proceed further in my research, especially when it was regard to the port environment management. And also when I was writing some articles on the rights of salespersons in they were not allowed to actually sit in shops in the Kerala shops in Commercial Establishment Act was actually amended uh, based on the human rights violations and all. So I had to actually adopt a methodology to speak to them and go and do some survey to understand uh, on field actually what was happening. So I feel that this type of interdisciplinary research will actually help you to know the real reality and it will actually complement our research and make it even better. And the right type of methodology that we adopt is what matters a lot. So that's what I feel. So anyway, thank you, sir. It was really interesting.
Thank you. Thank you. Can I just answer Rubin there, if that is okay?
Yes, sir. Yes.
Yeah, Dr. Soni, thank you for that. I was just saying, I'll come to Dr. Soni's, point on the methodology part. I'm a little concerned about the what methodology do we adopt usually, and can we borrow methodology from the other disciplines as well, and should we actually make a mixture of the same? So that's something that a lot of students, a lot of researchers are, quite confused about, and hence we are taking the statistical method, we are taking so many other methods from nowhere and adopting to legal research, which I think is not the right thing to do. I disagree with the fact that methodology from other disciplines have to be adopted. I say look at that discipline, but don't adopt that methodology. Don't confuse legal methodology with other disciplines methodology, because you will not be able to do justice. So your methodology should be yours. It should be properly from the legal dimension that the methodology should be adopted. I would always focus upon that. Anyway, now coming to Rubin's point, for me, uh, you know, comparative research is very core and important, right? Issues that arise from different jurisdictions also give you the dimensions of what can happen in society and what can happen as problems that law needs to respond and look into. But Ruben, the problem is when we look at cross-border kind of research, it also depends upon the kind of material that you get access to. And most of the time, we get material looking west, not looking east. And Ruben, for me, if I look at the Indian society, the legal system, looking east has always helped me. I don't know why. It's not looking west that has helped me much as well. But I think um, uh, it can be relevant, it can be important. We have to be very choosy in selecting the topic for research, in identifying the issues involved in the same, in adopting the outcomes of the same, as what are you going to achieve from such a kind of research. But more importantly, no two political systems are going to be the same. No political ideologies are going to be the same. The kind of ideological issues that India is facing today is unique to this country. I don't think you can find anywhere close to what we are facing in this country. The kind of polarization that we are seeing today in India, I don't think you'll immediately find it in some cross-border country so soon or so immediately. So that could be the advantage of the vibrance of our democracy and the freedom of thought process that we have always championed for or nurtured. But that's a different issue altogether, right? So I think the issue on politics is kind of challenging. It's great to get theories and look at legal discourse, but I think indigenization of the same then becomes the critical factor. Now, Rubin, I believe indigenization, I meant about the fact that whatever can I research about, I have to be able to use it, assimilate it, intersect it with Indian thought process, and try to indigenize it from my own perspective. I think that is where the relevancy of such kind of research becomes very relevant. Otherwise, our research is always in the paper. The research is not going to be read. It's not going to be useful. It's not going to be adopted. It's not going to be published. It's not going to be, application based, right? So to that, I would always say, do cross-border research, indigenize it, but see if first you can do so, and then probably move forward.
I don't think we have any more questions in the chat box, and we can probably.
Thank you, audience. You did not create too much of problem and trouble for me, so I'm very glad. I'm really grateful.